There are two different views of the Constitution. Party A holds view 1A, and that is the living Constitution view. That is this. It's the belief that the Constitution is a living document that changes meaning according to the changes of society. And judges should tell us just how the Constitution is changing. And therefore, judges should have the power to decide all the major issues facing the nation. 4 justices on the Supreme Court hold this view: Ginsburg, Breyer, Sotomayor, and Kagan. The opposite view, Party B view, is the Constitution has a fixed meaning. What is that? It's the original public meaning. That is, it's what the words meant when the Constitution was adopted. Judges should interpret the Constitution, not change it. Well, then how should the big issues in the country be decided? Freedom of religion, abortion, marriage, definition of marriage, and other issues. How should they be decided? Well, the way the constitutional writers set up those issues to be decided by the elected representatives of the people in the U.S. Congress and the state legislature voting and deciding, because they are most accountable to the people. It shouldn't be decided by the Supreme Court. And why is that important? It's because our whole nation is at stake. The fixed meaning of the Constitution is our foundational protection against the tendency of governments to usurp more and more power. 4 justices currently on the Supreme Court hold this view, this original meaning view: Roberts, Scalia, Thomas, and Alito. 4 on one side, 4 on the other side. That leaves 1 justice in the middle, Justice Anthony Kennedy. And the way he decides, whether he sides with the conservatives or the liberals, makes the difference in how many, many, many issues are decided. In fact, you voted on Proposition 8 here in California. The arguments are gearing up to go to the Supreme Court, whether that will stand or not, whether the Supreme Court will overrule your choice and say that same-sex marriage is the law of the land. The lawyers on both sides have primarily written their arguments to appeal to Justice Kennedy because they're quite sure that he by himself will make the decision. This is not the form of government that our founders set up for us to have, where one man, never elected by anybody, never accountable to the will of the people, and having life tenure, decides the major issues of the nation. It's not the kind of government that we were given in God's good providence when the Constitution was written. Now, see, when our founding fathers set up the government of the United States, they had to decide, to whom will we entrust the greatest power in the nation? They decided they wouldn't entrust the greatest power to the president, and they wouldn't entrust the greatest power to the Congress, and they wouldn't entrust the greatest power to the Supreme Court, and they wouldn't even entrust the greatest power to the majority of the American people. Our founding fathers decided, instead of entrusting the greatest power to any person, they would entrust the greatest power to a document, the Constitution, that would be above the Congress, above the President, above the courts, and above the people. Now, you could say, yes, the people can amend it. The people and the court and the Congress and the states can amend the Constitution. Yes, they can. Very difficult process. They can do it. But unless the Constitution is amended, the Constitution is the supreme authority in the land, and everybody else has to be subject to it. As long as that principle is maintained, the Constitution has all sorts of protections that protect us from what people fled from England to get away from, and that was a government that took more and more and more power, as governments tend to do, and the government that became a tyranny. And they set up the Constitution with the Bill of Rights and many other protections, the separation of powers and other things that would protect the people against the government. As long as that is protected, our system of government and our nation as we know it stays in place. But under the living Constitution view, view A, the judges can come along and they can say, oh, we found a new meaning here, and it really isn't what it meant originally, but they make up a new meaning and they say, that's our interpretation. Now let me tell you how that would go. If you're driving If you're driving 60 miles an hour in a 30-mile zone and you get stopped and you say to the officer, well, I interpreted 30 to mean 60. He would say, good luck, buddy. You can't just change the meaning of words to your own liking. But that's what's happening. Let me show you a couple of examples. Let's see if we could get the PowerPoint up here. I think I need to do this. th Amendment. The Civil War ended in 1865. 1868, the 14th Amendment was finalized and approved. It was just after the Civil War, and the purpose was to be sure that freed slaves had the full rights of citizenship. So any person, all persons born or naturalized in the United States are citizens. And it went on and said, nor shall any state deprive any person of life, liberty, or property without due process of law. There were laws prohibiting or restricting abortion in about 37 states at the time the 14th Amendment was adopted. I don't think one human being in the whole United States thought that the meaning of those words, those yellow words, had anything to do with abortion or guaranteed a right to abortion. That wasn't what the words meant. But in 1973, the Supreme Court looked and looked and looked at those yellow words, and they said, behold, these words guarantee any woman can take the life of her unborn baby at any point in pregnancy. You say, I don't quite see that in those yellow words. And you're right. It's not there. But the Supreme Court said it was there. And so for all practical purposes, the meaning is there for the whole country. And all 50 states, all of their laws that had anything to do with restricting or prohibiting abortion in all 50 states, in 1 second, when that decree was issued, the laws were wiped out, because the Constitution is the supreme law of the land. And by changing the meaning of the Constitution and calling it an interpretation, the judges figured out that they could decide that issue for us. And there is nothing you can do about it. Nothing. Congress can pass laws against abortion. They'll overrule it. They'll say it's unconstitutional. States can pass laws against abortion. They'll say it's unconstitutional. This is the supreme authority in our country. If you get hold of this and you can tamper with it at your own will, all of a sudden you rule the whole country. You see the problem? I'll give you another example. First Amendment. Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. At the time of the Constitution, the Founding Fathers knew what establishment meant, because they had come out of England where there was an established church or a state church, the Church of England. You had to go to it. You had to support it. And there were times when if you didn't preach in the state church, you started preaching elsewhere, you'd be put in jail. They wanted nothing to do with an established official church in the nation. And so James Madison, the first proposal for the wording of the First Amendment, he said, Congress shall make no law establishing a national religion. That's what he was trying to rule out. It meant the Church of England wouldn't be the official church. The Baptist church won't be the official church. The Catholic church won't be the official church. No established church. That's what the words meant. Now, in committee, the wording got changed, so it came out, Congress shall make no law respecting an establishment of religion, but all it prohibited was a national official church that everybody had to support. That's all it prohibited. It didn't prohibit any freedom to speak your own religious views in public, because it even ruled out, it said you can't prohibit the free exercise of religion. Now, when a high school valedictorian gives a speech at graduation and her principal says, you can't put in a Bible verse or mention Jesus, that's prohibiting the free exercise of religion. That's violating the First Amendment. But the Supreme Court has said in its new interpretation, Lemon v. Kurtzman in 1971, the Supreme Court said a government action, and that includes, according to their interpretation, that includes any activity sponsored by a high school, like a graduation or a football game where you might want to have a prayer, or a city council meeting where you might want to pray. What has happened is, again and again and again, these freedoms of religious expression have been restricted, because they said in 1971, a government action must not have the primary effect of either advancing or inhibiting religion. That's religion generally. I mean, if they said government action can't force you to attend the Baptist church or the Catholic church or the Presbyterian or Episcopal church, then okay, that's the original meaning. But when they said you can't even do anything to help religion generally, that means that public school teachers can't say they believe in God or tell children that they should believe in God, or they're accountable to God for how they act. Why not? That's advancing religion according to this new interpretation of the Supreme Court. Now, I think the Bible says something about this because Romans 13:1 says, "Let every person be subject to the governing authorities." In the first century, when Paul was writing, that meant be subject to the Roman Empire. But in our nation, in our lifetimes, it means be subject to the highest authority in the land, which is the Constitution. But if you begin getting in as a judge and tampering with it and changing it, you're no longer subject to the governing authorities, the highest authority over our nation. You are destroying and violating the meaning of that highest authority. So I think this living Constitution view is a disobedience to Romans 13:1. It's not being subject to the authorities that were established over us in the history of this nation. And incidentally, people can say to me, "Well, how are you participating in Pulpit Freedom Sunday? Doesn't the Bible say Romans 13:1, let every person be subject to the governing authorities?" The nature of tax law is tax laws can only be challenged in court if someone is found in violation. So the Alliance Defending Freedom, which I really like a lot, it's a Christian legal defense agency, they said we've got to get some pastors to endorse candidates by name or parties by name from the pulpit so that the IRS will find them in violation, so that we can bring it to court, because we're quite confident that we will win on constitutional grounds. Telling pastors what they can say in the pulpit is a violation of freedom of speech and a violation of freedom of religion. It's unconstitutional. And I think if the IRS will ever bring anybody into court on this, that the Alliance Defending Freedom will win. That's why I have actually posted on a website called christianpost.com. This morning, they posted an editorial that I wrote called "Why I Am Participating in Pulpit Freedom Sunday." I've never done this before. I've never violated the IRS code before in my life. I don't know if I ever will again. But Pastor Jack invited me to come, and I thought, yes, let's do this. And hundreds of pastors have done this in the last 4 years, and the IRS has done nothing. I think they know they'll lose. That's issue number one. Oh yes, in the middle column in issue number one, I have Deuteronomy 17:18. That's a reminder that even the king is subject to the law in the Old Testament, because the king had to write a copy of the law in a book when he became king to remind him that the law was above him. He wasn't above the law. We see that in the tragic story of David with Bathsheba. He sinned with Bathsheba. Nathan the prophet came to him and said, "You are the man. David, you have sinned. You have violated the law of God. You are not the supreme authority in this nation. We are not subject to human whim and varying opinion. We are subject to the law of God." I think in the analogy of that, our founding fathers set up a system where we're subject to a law that's higher than any person, and that is the Constitution. It's not equal to the Bible, but it functions in a similar way in that it's a rule of law versus the rule of human beings, fallible human beings. That's the difference. Now, here's what I'm going to do, what I've never done in my life before. I'm going to tell you which is Party A. And which is Party B. The Democratic Party and President Obama are Party A. They represent a liberal view on these issues. These views are contrary to biblical moral teachings, and I cannot recommend that anyone would vote for President Obama or Democratic candidates. They are, to my mind, what Isaiah 10:1 says: "Woe to those who decree iniquitous decrees." What about Party B? Now look, before I identify Party B, I want to say you might be a visitor here this morning, or you might be a Democrat, and you've voted Democrat all your life, and you're still not convinced, and you're going to vote Democrat. I want to say I don't want you to feel isolated or abandoned here in the congregation when everybody else is clapping. I will defend your freedom to disagree with me, because this is a free country, and I love the fact that it's a free country, and we can disagree. Okay? So, but I will say, here's the opening of the secret now. The Republican Party and Governor Romney represent Party B on this chart. No one comes to national leadership in either party without holding to these positions. These views of Party B are consistent with the Bible's moral teachings. Therefore, I recommend that every citizen vote for Governor Romney and Republican candidates generally.